law matters. Yes, it does. And we're here to help you understand it a bit better. Welcome, I'm Deb Moraes, your host and your moderator. For nearly a decade now, this program has been dedicated to making legal information and topics accessible to you. We offer clear insights, we offer real-world examples, and practical advice to help you navigate the complexities. A solid understanding of the law puts you in a better position to understand how to protect yourself, your business, and your family. And through these discussions, as we say, you may find that you're able to handle some issues yourself. We're happy about that. However, if you decide that you need outside counsel, you'll be better prepared, and so will the counsel you select. Of course, that's our goal. We are hoping always to save you time and money, and we want you to achieve the best possible results. As always, we want to welcome and thank Attorney David Bazar from the Bazar Associates law firm in East Providence, who continues to weigh in on every topic that we discuss, and he gives us wonderful examples and anecdotes, and he will today also. Today we're going to be talking about irrevocable trusts. We've spoken about trusts before, Medicaid Asset Protection Trusts, and something called Life Estate Deeds. You've probably heard of them, but they're complex, but things that you should know about. So what are these instruments, and what's their value to you, and how do you make them work for you? Sometimes it means you're giving up protection when it's irrevocable. What does that do, and how does that work? So before we begin, I want to say in our follow-up section, segment, we are going to be continuing the discussion, but in a very specific vein, which is on special needs trust, a different target audience and a different instrument. But let's begin with what a Medicaid Asset Protection Trust is. How does it work? What is it?
So a Medicaid Asset Protection Trust is an irrevocable trust. And what happens many times is people will come in and they'll have a concern about protecting assets for the next generation. They've worked hard, they've acquired a home and some money and maybe a retirement account or some other things. And they're afraid that they're getting older and they may end up in a nursing home and it'll wipe out all of their assets, and they want to try to make sure that their children get something. So in order to qualify for Medicaid, you have to have, it's really basically a welfare program. You can't have much money, and there are some limitations on what you can have for a home. You're allowed to have a home in Rhode Island. In Massachusetts, they let you have it home for a year, and then you have to make a decision if you're going to sell it or whatever. They want you to use your money to pay for your care, and that's understandable. So in order to not have to sell your home in Massachusetts and in Rhode Island, well, they won't make you sell your home if you intend to return home, but to make sure it's protected in the long run, many people want to create a trust that will provide that protection. And so in order for it to provide the protection, you have to give up control. And what that means is you can't be the trustee, you can't be in charge of the trust. You can be, in Rhode Island, a beneficiary of the trust while you're alive, allowing you to live in the home, but you can't have any control over the trust. And there is, as you know, a 5-year look-back period for any assets that you put into the trust that if you apply for Medicaid within the 5 years, you have to disclose, and it could be disqualifying.
How does someone start to set up such a MAPT, I guess they call it, Medicaid Asset Protection Trust? How do they start to set that up? Do they do it at the same time they do their other trusts? How does that work?
So when someone comes into us for any initial estate plan meeting, we like to have them fill out a form that tells us about their family, it tells us about their assets, and then I like to sit and go through with them what their concerns are, what are their goals, what keeps them up at night. And oftentimes there'll be conflicting issues. They want to make sure that they avoid probate, they want to get assets to their children, they don't want to give up control at this point in time, but they want to protect assets. So when you have some conflicting things, you have to really dig in and try to find out, well, where are you at? How's your health? What's going on? What is driving your concerns? And many times it's premature. They're not ready to give up control. So a Medicaid Asset Protection Trust may not be something for them at that point in time. Or it may be that's their driving concern, and they want to say, I've got children, I want to make sure my children get the house, and I want to do whatever I can to do that now. And so then the discussion begins with the Medicaid Asset Protection Trust, especially if there's a number of children.
So you say that when someone does this, they can live in the house, so can their spouse?
In Rhode Island, yes, you can set up a trust that gives you what is equivalent to a life estate, meaning while you're alive, you get to live there, you have to pay the bills, no one can put you out of the house while you're alive, and in fact, we can create it in Rhode Island as a grantor trust, meaning that you're setting it up, it's using your Social Security number, it's set up so that if you sold it, it passes through to your tax return, not a separate trust return, and you can maintain, because of that, many of the exemptions you might have for property tax, such as a homestead exemption or a senior citizens exception or a veterans exemption, whatever you may currently have. We draft the trust in such a way that says you're living there for the rest of your life, so it's similar to a life estate. You have the right to be there until you die, and you're maintaining certain other tiny bit of control, not enough that would require you to sell the home, but some a power of appointment or whatever that for tax purposes gives you the right as a grantor to have a grantor trust.
So you mentioned, we were talking about these maps, you mentioned a life estate. What's the nuance or distinction between the two? Is the life estate just and only about real estate?
Yeah.
Or how does that work?
So a life estate deed is a deed where you transfer the property to a child or perhaps children and retain the right to live there, or the life estate interest in the real estate. So while you're alive, you own it, subject to the fact that when you die, it's going to go to whoever you deeded the property to. Many lawyers like to use that as a shortcut to a Medicaid Asset Protection Trust. There are some advantages to doing that, but there's a lot of disadvantages.
Okay, that's the next question. What are the pros and cons? What are the advantages and disadvantages?
It's less expensive generally to deed property to somebody else rather than creating a trust, but it can create a nightmare if it's done in certain circumstances. And I've had a case recently where a lawyer deeded the real estate to 7 children. The mother and father retained the life estate. The father died, so the mother had the life estate. And then when the mother died, the 7 children, 2 of them had already died before the mother. So what's the purpose of deeding a property through a life estate? The main purpose is to avoid probate, because they already own it, so it automatically becomes theirs on your death. The problem is, in that case, when there are so many children and so many different things that can happen, and it was deeded to them each of the children as tenants in common, which meant that they own it. It wasn't with right of survivorship. So what happened was we had to probate the 2 estates. And one of the folks who died had a wife and no children. And so his share, or I should say his wife's share, which was one of the children, and she didn't have a will, goes by intestacy law. This is really about as hard a law exam question as you could get.
Complicated.
So what happened there was he owned a life estate interest as the surviving spouse. The mother who survived the daughter had the remainder interest because she had no children. So intestacy in Rhode Island goes down to children first, then back up to parents. So since she survived, I had to probate her estate for her little remainder interest that she had. And then the other son who died had a daughter, so we had to probate his estate. His wife had died before him, so his share went directly to his daughter. So what happened was we ended up probating 3 estates instead of no estates.
That's very complicated.
Yeah, and so I generally will tell people, if there's more than one, maybe two. Not to use a life estate because it can get complicated if somebody dies before you.
Also, who gets taxed where along the line? An interesting,
Yep.
an impactful issue.
So there's a lot of different kinds of tax with real estate. So the property tax, that goes to, during a life estate, the person who's still alive because they own it. So during your life estate, one of the things you have is the responsibility of paying the property taxes. Obviously, when you die, the property automatically passes to the people with the remainder interest. So then they'll be paying the property tax. But the question becomes if they're going to just sell the property, do they have capital gain and estate tax? So the property is subject to estate tax. So if the estate of the person who died is over $1.8 million in Rhode Island, there would be estate tax due. If it's below that, no estate tax will be due. But you do get what's called a step up in basis.
That's what I was going to ask. So explain that.
So what that means is that the people who are on the deed, subject to the life estate, the remainder interest folks, when they get the property on the death, the date of death value that you use for the estate tax return becomes their basis in the property. And the basis is kind of equivalent of what someone pays for property. So when you sell the property, capital gain is based on any gain over what you paid for it, or in other words, above your basis. So generally speaking, if you inherit property through the life estate, so to speak, you're now going to have it at that increased basis. And if you sell it rather quickly, there's not going to be much of any capital gain.
So about the example that you were giving, we've talked before about estates and how you take care of your children. What happens, how do you take care of the one who might not be good with money or managing money, who might have issues? How does that impact on that life estate when you're planning for a child who might cause trouble or have trouble? How does that impact on it?
Okay, so that's the other downside of a life estate deed. If you're trying to pass your property to your children to avoid probate, and you're using that process to do it, the issue is you have no control over what happens to the real estate once your child gets it. It's an outright gift. So you're not putting it into a trust for them as you could do with a Medicaid Asset Protection Trust or a Revocable Trust. You're not controlling their inheritance at all. It's an outright gift. So you have no control. And the other thing is, right now in Rhode Island, we can do a life estate deed to avoid the Medicaid issue. Mass, it's more difficult because Mass has what's called extended estate recovery, where Rhode Island only recovers what they pay out right now through probate. So since the real estate passes outside of probate by the nature of the life estate deed, it does not get recovered by the state for whatever they paid out for Medicaid, as opposed to if you didn't do that and it was in your name and it went through probate, then whatever the state paid for Medicaid, they would recover from that house or whatever other assets are in probate.
I think we need to expand on that a little bit, but when we began talking about Medicaid Asset Protection Trusts, we did talk about real estate, but let's go back to, I know the reason that you put this together is so that you don't have too much money, as it is when that time comes. What else goes into this MAPT, as it's called, besides potentially your house and or your vacation house, maybe, whatever?
Yeah,
what else goes in it?
You can put anything into that trust that you do not want control over or don't care about having control over. So if you're naming your oldest child or your brother or sister as the trustee, and you trust them and they're going to do what you want, you can do that. Generally, what we do with a Medicaid Asset Protection Trust is you, as the beneficiary while you're alive, would only be entitled to income. So it would be an income-only trust for you. The principal would be available to your beneficiaries, your children usually. And the reason we do that is because if you do put other assets besides your house in that produce income, a bank account, a stock portfolio, or whatever it is, and you're used to living on that income, or an investment real estate property, or a vacation home, not so much, but if you own rental property and you want that income, then you can put it in and be the beneficiary of the income. The income will count towards what you have available to pay for your own nursing home, which is fine. The property itself will still be protected after 5 years.
So this property, you mentioned other bank accounts. So your bank accounts, your CDs, stocks and bonds, but what else should go in there? Your life insurance?
You could.
Annuities?
I don't know. It depends on the type of policy. If it's a whole life policy with a lot of cash value, it might be something you'd consider putting in. Most people that I deal with put in the home. They'll put in rental property if they have it. Mm-hmm. Sometimes they'll put in an investment account, a type of portfolio of stocks and bonds that they have if they don't really need access to the principal anymore. Okay. Those types of things.
I understand that you don't put in an IRA or a 401, and why not?
Yeah, so any retirement asset, technically, if you retitle it, you're changing the ownership. And when you put something into a trust, you're retitling it. So a bank account that's in your name that becomes titled to the trust is now the owner of it rather than you. Same thing with the retirement account. And when you do that, just like if you took that retirement account out of for the benefit of you, fidelity for the benefit of you type of title, and just put it into your name, you're cashing it in, so you have to pay the income tax on whatever you take out.
Good to know. Other things that you might suggest, vehicles? Do they go into?
No. You can't really put a vehicle into a trust, mainly because you can't register a vehicle to a trust, and secondarily because insurance companies don't know how to insure a trust. They don't know how good a driver your trust is. I'm just kidding.
Yes.
But it's difficult to put a vehicle into a trust.
And then at the same, when we've talked about wills and trusts, your personal belongings, your furniture, they don't belong in.
Well, you could put those into a Medicaid asset. You could.
Your wife's diamonds?
You could. I mean, when we do a revocable trust, we always assign the personal property into the trust.
But this is irrevocable.
But an irrevocable trust, you have to think long and hard as to what you want to give up control over.
Completely, yes. Okay. So you mentioned that you do this, and there's that look back period. It's 5 years. Is it always 5 years?
Depends on the state you're in.
Okay, good to know about the state. So there's one other little wrinkle not such a little wrinkle, that you mentioned or alluded to earlier, which is, and I think a lot of people don't know about this, it's the thing that was that estate recovery part of what happens. How does the state manage to recover funds from your estate once you're gone? Under what circumstances does that happen?
Again, like the look-back period, every state can have its own rules. Medicaid is actually managed by each state. The federal government does put money in, hopefully continues to put money in, but the state manages its own Medicaid rules. And in some states, they have expanded estate recovery, which means it's not just probate that they look to see what's in your estate, but potentially a life estate deed they could look to, and anything that passes on your death is part of your estate if it passes on your death. Rhode Island, like I said, right now their rule is they recover only by putting a claim for whatever they paid out against any probate estate.
So we talked about trusts earlier. Whatever went in the trusts, that's not probated, so they don't have access to that for recovery purposes.
Right. Other states might.
Other states
with
might.
Expanded real estate recovery.
Also, states have different costs for the nursing home. But apparently, all right, so what happens if after you've done this mapped and you still have more money than you should have for it? What does a spend down program look like, whether it's here or what do people need to know about that, David?
So there's a number of different things that you can do to get yourself otherwise eligible for
eligible.
Medicaid.
Yes.
And so, as I said, in Rhode Island, even if you own a home, that doesn't count against you. It's not a disqualifying asset as long as you intend to return home, and especially if you have a community spouse or stay-at-home spouse. So if you had a home with a mortgage or needed some work on it, one of the things you could do is put money into the house to make sure it's maintained for the stay-at-home spouse, or pay the mortgage down, or any of those types of things. That's one way to spend down money. Many people will have somebody take care of them and keep them out of a nursing home for a good period of time, and they're allowed to pay for that. And so that's a care agreement that you can enter into someone, so that you're paying for your care. And it can be a relative, but it has to be an arm's length transaction, documented, and to say what you're paying for and what they're doing for you. There's other ways of spending money down, which you can prepay a funeral bill, for example. In fact, you talked about life insurance. Many times people will assign a life insurance policy if it's a smaller, well, not too small because funerals are expensive,
yes.
but something that can help pay for a funeral or actually prepay for the funeral. You're allowed to do that. You are actually, in Rhode Island, allowed to own a car. So you wouldn't even have to put that into that trust if you could, because you're allowed to have a car. You can do a situation where you have some money that you want to give away, and in order to qualify and be otherwise eligible, you may give away enough money that you're qualified for it. At the same time, you loan an equal amount of money to another person who will pay you back enough money to pay for your nursing home for the period of time that you're otherwise ineligible because of the gift that's within the 5-year look-back period.
So I was about to say, it sounds like planning these things, it's not a do-it-yourself project at all. What about the fact that it costs to do these? Is this an expensive proposition? I know it depends on the complexity and the assets and all. And is that fee something that counts for the spend down?
Yeah. So there are a lot of attorneys that will specialize in what I would call emergent planning, where you're about to go in and you don't have 5 years, and you might even have 5 months. And so,
really,
what is the average cost of a nursing home in Rhode Island? 12 to 15,000,
yes.
something in that range.
Could be.
So
yep.
You might pay a month's worth of nursing home care to an attorney to put a plan together that saves you a considerable amount of money. I always tell people it's a good idea to have enough money to pay for some time in a nursing home, so you get to pick where you're going to be, make sure that if you run out of money, they have a Medicaid available bed that you would be in, but you should be able to decide where you're going to stay. So don't give all your money away and have no control over where you're going to be. But this plan where I told you, where they might loan some money and give some money, and the money that's loaned can pay for the nursing home for a period of time, might be a good way to be able to accomplish both things, saving some money, but deciding where you're going to be.
So you're saying that it's not just a matter of doing a trust that's revocable, plus one that's irrevocable, plus this other instrument, or another strategy, so to speak. Do those things all take 6 months to take care of? Do you need to have that? I mean, you talk about a 5-year look back. If you're planning ahead, how much of that do you have to look back? Do you have to plan for this 6 months if you have 6 months to plan?
Some of these things can be put together in a much quicker fashion.
If it's emergent.
If it's emergent.
Yes, okay.
But if you have time, it's better to try to put something together if you can in a longer time frame, such as more than the 5-year look-back period. But no, things can be done much quicker if you need to. But you lose some of the options, because as you said, there's many strategies that you might employ, but you're going to lose some of those strategies if the time frame gets crunched too much.
And you mentioned, too, that as an alternative to a nursing home, which is becoming popular, well, I guess it was always popular, it wasn't always practical and doable, but for someone to pay for in-home care, or perhaps it's the bed, it's paying for retrofitting the house. Are all of those things that help qualify for spend down or alternatives, or those strategies that work?
Anything with the house that's done to keep you out of a nursing home for sure would be a legitimate spend down. A lot of people don't want to go to a nursing home. They want to stay at home. And some states, Rhode Island among them, have programs where they'll help pay for care to keep you at home. And for the state's purposes, it's a lot less money to pay for some help to keep someone at home than to pay the cost of a nursing home. So if you might otherwise qualify for some help to stay for a nursing home, you might qualify to stay at home. And the other thing is long-term care insurance. And a lot of those long-term care policies will also provide benefits for people who want to stay at home and help provide for CNA or nursing help to come in to be able to keep somebody at home.
And is that, so if someone's taking, they have an IRA, they have a Social Security, and they have just still too much money, even that income that comes from the maps that you do, that still all is countable by Medicaid. It still might mean that they have to do even more to bring that money down, does it? I mean, if they're getting income from this, how does that work? It's really hard to do that.
The retirement accounts generally that are paying out the required minimum distribution,
yes,
the required minimum distribution will count as income, but the money that's in that account will not disqualify you otherwise for a nursing home.
It is complicated. Do you generally dissuade people from thinking first about irrevocable? Do you generally say, let's look at the revocable?
It depends on the situation. That's why I start with, what are your goals? What are your concerns?
Okay.
What is your family situation? How's your health? Let's talk about all of those things before we decide what direction you need to go in.
And I guess, as we've talked about it before, when I've asked you, well, how often do people need to change or review things, and you say if there's a change in their life circumstance, someone born, dies, whatever, that must mean that when someone still has a revocable trust, they would always need to check back more frequently than if it's irrevocable, except for perhaps with the beneficiary, because you can change that at any time. Is that true? You
can have some control over the beneficiaries. You can't have control over the assets.
Good to know. These things certainly are complicated. We hope that our discussion of Medicaid Asset Protection Trusts has been helpful to you. In our next segment, we're going to explore this a little bit more and with a different target in mind. So we hope that you'll continue to stay tuned to The Law Matters. As we say, it matters to you. Thanks for tuning in.